We're jumping straight into the fire. Cardi B's name alone raises the stakes. Every glance, every hesitation from this witness could shift how the jury sees the truth. Watch closely. The smallest yes or "I don't remember" can change everything.
With a slight adjustment. Your lawyer showed you photos of the building that you were working on at as a security guard in February 2018. Do you know the name of the building?
I don't know the name.
Was it Beverly Hills Medical Center?
It could have been, yes.
Yeah, it was a medical facility, right?
Yes.
And the incident that you claim happened that day happened at approximately 1:30 p.m.?
Approximately, yes.
And you knew at the time, when you saw Cardi B, that she was going to a medical appointment, correct?
I didn't know where she was going, but she was at the building.
And you understood that she was going to a medical appointment, right?
She was going to an appointment, yes.
And it was a medical building, right?
Yes.
And your deposition was taken, and you said that you testified under oath in your deposition. Let me ask, do you remember your deposition was taken in this action?
Yes.
Do you remember taking an oath at the deposition to tell the truth?
Yes.
You understood when you saw Cardi B that she was going to a medical appointment, right?
Yes.
Now, after this incident, you talked to your supervisor at Allied, right?
Yes.
And she told you to submit a incident report, correct?
Yes.
And you emailed an incident report to your supervisor 2 days later, right?
I don't know about 2 days, but I sent it to her, yes.
Yes. And it was by email.
I'm not sure how she received it.
Your Honor, if we may, I'd like to show the witness the incident report that she did not produce in discovery.
To refresh your recollection.
I would object to that based on authenticity. It's not.
This is a document that we got from Allied pursuant to a trial subpoena. And it's not in the book. So let me provide a copy. Should I hand it to the clerk?
You can push.
I'm sorry? Oh, thank you, Your Honor. Let's make sure. Here we go. Does that refresh your memory that you sent an email to your supervisor on February 26, 2018?
Okay.
Do you recall that now?
I don't, but I'm looking at what you gave me.
And that's your email address, right?
Yes.
And it's addressed to your supervisor, Jasmine?
Yes.
And it's dated February 24, 2018? Oh, I apologize. It's dated February 26, 2018. And the subject is 224-18 incident report. You see that?
Okay. I see
Ma'am?
it, yes.
Yes. Okay. Now, before we talk more about that incident report, do you remember receiving in this case discovery requests that you had to verify under oath, where people asked you questions and about documents?
I'm not sure.
Well, let's see if we can refresh your recollection. With client's response.
Which one is it?
If I may, Your Honor, to explain to counsel that it's plaintiff's response and objection to defendant Cardi B's demand for production of documents, set 2. And may I approach?
Sure.
Thank you. Look to the last 2 pages. Is that a verification by you, signed by you, under oath, that the statements in the response, excuse me, are true and correct?
I'm sorry, were you asking me?
Is that your signature on the last page here?
Yes.
And you verified that, you signed stating that under penalty of perjury, the statements in the document are true, correct?
Yes.
Okay.
I'm not sure.
Well, please look at it. If you could please look at pages 5 and 6. That plaintiff has no emails related to this lawsuit.
Notice that move. The attorney reminds her of her oath. This isn't casual chatter. It's psychological pressure. The subtext? You better not lie now. It locks the witness into accountability and plants doubt for the jury.
Response, another sworn response. Your Honor, I would like to show the witness plaintiff's responses to defendant Cardi B's special interrogatories, which, rather than asking for documents, ask for information. May I approach?
Go ahead.
Where's the date of the document?
It was served on January 3rd, 2024, and the verification is dated January 30, 2024. Yeah? Well. And that's your signature at the last page, verified under oath that the statements in the document are true and correct?
It's my signature, yes.
Okay, and you understood that you were verifying under oath that the statements in that document were correct?
Yes.
Okay. And in that document as well, you said you had no emails related to this incident, this lawsuit, right?
I'm not sure if I said that in this document, but
Could you please look at pages 4 to 5? In fact, you say it 5 times. If memory serves, it's in bold.
okay.
And you never produced the email that you sent to your supervisor on February 26th in 2018 in this lawsuit, did you?
I don't have access to that email, sir.
My question to you is, did you ever produce that email?
I'm not sure I know what you're asking.
Did you ask, you had discovery obligations, Miss, did you ask Allied for a copy of the email that you are now testifying you couldn't access?
I wasn't in communication with Ally.
Okay, so let's talk about what you said on the email to your supervisor 2 days after the incident. If you look at page 1, it states that you were the...
Boom! An authenticity objection. It sounds technical, but it's a chess move. If that incident report can't be proven legit, her entire testimony could crumble. Lawyers love this. It shifts focus from memory to evidence.
And I had, quote unquote, I had 2 cell phones, the work phone and also my personal phone. I had my cell phone to my ear. Do you see that language?
Okay.
Do you see the language?
I see it, yes.
And you wrote that 2 days after the incident?
I don't remember writing this, but if this is what you have, then
Your Honor, I would ask that you read the whole sentence for completeness.
I don't have it in front of me, so I don't know that, but to the extent.
Well, that's the portion I intend to read. I mean, he's welcome to read whatever he wants to read.
Well, he's just reading half a sentence. It would be unfair for me.
Why don't you provide a copy?
Yes, Your Honor. Well, let me actually include the declaration that came with it of Allied.
Sorry.
Too much stuff. And we're talking about the first paragraph.
It does appear to be a narrative, so if you want to read everything in context, that would be great.
Should I read it, or are you asking her to read it?
No, go ahead.
Okay. And just that sentence, Your Honor?
Just read it. Whatever it is, make sure it's just in context.
Okay, thank you. Again, the context is that you state in this that you are a daytime guard on duty at 8920 Wilshire Boulevard. Per usual, I was conducting a routine patrol of the building premises And as part of that patrol, I checked the rooftop, all tenant levels, and parking garages. At approximately 13:30 hours, and just to clarify, that is 1:30, correct?
Yes.
I was finishing a patrol on the 5th floor of the building. In my hand, I had 2 cell phones, the AUS work phone, and I also had my personal cell phone. I held my cell phone to my ear, checking my voicemail because my mother is recovering from cancer and is in chemotherapy, so sometimes I don't get the calls and have to check the voicemails. You remember that?
I'm reading it with you, yes.
And are you telling me you have no recollection of this 2-page email detailing the event that you've sued over?
I remember writing an incident report and sending it over.
Well, do you recall also that you produced in this case your T-Mobile cell phone records, correct?
Yes.
And if I could, I believe that's something we can display because it is an exhibit.
Can you share, Your Honor, may I ask if they can share the exhibit number, please?
So why don't we, just to move things along, why don't we take our afternoon break now? Ladies and gentlemen, we're going to take an afternoon break. Since we have a couple things to discuss and I need to give the court reporter some time off, why don't we resume back at 3:15? In the meantime, please come up.